Yes, and I'm certainly delighted to be back.
Okay, I'm going to start with just a quick correction that Mr. Austin asked me to make from the last panel. He had referred to a gentleman named Steve Taylor, but his name is Stephen Parker. So just that correction from the previous panel. Okay, with that, I'd like to introduce our second panel of the morning, focusing on voting rights. This panel will address current voting rights challenges and strategies for reform, whether through litigation, legislation, or mobilization. The panel moderator is Steve Mulroy, who's a professor of law at the University of Memphis Cecil C. Humphrey School of Law. Professor Mulroy teaches in the areas of constitutional law, criminal procedure, and civil rights, and is a former civil rights lawyer for the United States Justice Department and former prosecutor. As a law professor, Professor Mulroy has participated in the litigation of a dozen cutting-edge cases in areas which inform his scholarship. He also served as an elected Shelby County Commissioner from 2006 through 2014. I'll also like to introduce our panelists, at least briefly. Mr. Debo Adegbile, a partner at Wilmer Cutler Pickering Hale and Dorr in Washington, D.C. Next to him, Ms. Sherilyn Eiffel, President and Director Counsel of the NAACP Legal Defense and Education Fund. Then Professor Mulroy, and to his left, Pamela Carlin, the Kenneth and Harl Montgomery Professor of Public Interest at Stanford Law School, and at the far end, Rick Hasson, the Chancellor's Professor of Law and Political Science at the University of California, Irvine School of Law. So I'll turn it over to Professor Mulroy to moderate our panel.
Thank you, Dean Letsu. And good morning to all of you. Good morning. Glad that you're here. Thank you very much for coming, and I want to thank our panel as well for coming from different parts of the country to participate with us today. I'm going to briefly introduce each of our panelists, give a little bit more detail, and then I'd like to foster a discussion among the panelists, and I'll get to that in a moment. On my far right, as Dean Letsu already mentioned, is Debo Adegbile. He is a partner at the law firm of Wilmer Hale in D.C. He is actually currently serving as a commissioner on the U.S. Commission on Civil Rights, having been appointed to that position by President Obama. At the law firm, he co-heads the law firm's anti-discrimination law practice. He also, in the past, had served as an acting president of the NAACP Legal Defense and Education Fund, had testified on a number of occasions before Congress on voting rights issues, and also litigated two important Supreme Court cases having to do with the Voting Rights Act, Namudno v. Holder and Shelby County v. Holder. So we're very glad to have him here. Next to Debo is Sherilyn Eiffel, who is currently serving as the president and director counsel of that same NAACP Legal Defense and Education Fund, where she had spent a number of years litigating a number of different voting rights cases. When I was at the voting rights section of the Department of Justice, we often worked with the NAACP LDF. They're one of the preeminent organizations in this area. She's a critically acclaimed author, and her book, On the Courthouse Lawn, Confronting the Legacy of Lynching on the 21st Century, reflects her lifelong engagement in an analysis of issues in American public life. To my immediate left is Pam Carlin, who is the Kenneth and Harl Montgomery Professor of Public Interest Law at Stanford Law School and the co-director of that law school's Supreme Court Litigation Clinic. She has also, in the past, served at the NAACP LDF. She clerked for Supreme Court Justice Harry Blackmun. And she also served at one point as the Deputy Assistant Attorney General of the Civil Rights Division of the U.S. Department of Justice. Finally, on my far left, we have Rick Hasson, who is the professor, who is the Chancellor's Professor of Law and of Political Science at the University of California, Irvine School of Law. Professor Hasson is a recognized national expert in election law and campaign finance law, co-authored a leading casebook in that area, and currently manages the influential and indispensable election law blog and election law listserv. And he was also elected to the American Law Institute in 2009. So thank you all very much for being here today. What I wanted to mention before is I'd like to simply facilitate a discussion among all of you. I'm going to ask some questions that I'm going to throw out to any panelist who wants to answer. You're not required to answer. You can answer more than once. And if you have questions or comments among each other, I encourage you to discuss it among yourselves. I'm just here to facilitate. So with that, let me begin with this question. Not all of you are professors, but a lot of you are, and all of you are familiar with the concepts of grading. If you were to grade the progress that we've made since Dr. King's time in the area of voting rights, what grade would you give? In your opinion, where have we succeeded? Where have we failed? And to the extent that Dr. King's vision has only partially been achieved, why do you think that's the case? Anybody wants to start?
Okay. Well, what you left out of my bio is that I was a professor for 20 years at the University of Maryland Law School. So I'm quite familiar with grading, but the truth is I always preferred comments to grading, so I'm not going to issue a letter grade. But I will respond to the spirit of the question, what has been successful and what has not been successful. I think there's no question that the movement to ensure that African Americans have the ability to participate in the political process in this country, particularly in the South, has been one of the areas of tremendous progress in this country. The 1965 Civil Rights, Voting Rights Act is often referred to as the crown jewel of civil rights legislation, and understandably so. Now, without question, those jewels shone more brightly prior to the Supreme Court's decision in the Shelby County case, when we still had Section 5 of the Voting Rights Act, which required a number of jurisdictions with a history of discrimination in voting to submit any voting changes they wanted to make for preclearance to a federal authority. This was extraordinary because this was the one civil rights statute that allowed us to cut off discrimination at the pass before it happened. And it was remarkably effective. Now, I'm not one of the people who thinks that the preclearance years were Shangri-La, because like a number of the people on this panel, I litigated voting rights cases with the preclearance provision, and we never lacked for work. So we know that Section 5 did not produce Brigadoon, but it did allow us to proactively engage issues of voting discrimination. If you look alone at the tremendous change in the registration of African Americans in the South, particularly immediately following the Voting Rights Act, it was almost extraordinary. Counties like Dallas County, Alabama, where African Americans constituted 51% of the population, only 1% of African Americans were registered to vote prior to the Voting Rights Act. And so this was an extraordinary a piece of progress. I think it's also true that there's been tremendous progress in electing African Americans to political offices around the country, at the local level in many jurisdictions, some at the state level in some states, and certainly even the President of the United States. And I certainly think the election of the President of the United States, and by that I refer to Barack Obama, would not have been possible without the passage of the Voting Rights Act. And the passage of the Voting Rights Act came as a result of tremendous activism, tremendous courage by people like John Lewis and others who marched across the Edmund Pettus Bridge, and who insisted on the importance of this Voting Rights Act. But that being said, I do want to make sure that we are clear about Dr. King's ambitions and what he thought voting rights meant and would do, and what he and many others in that movement thought voting rights would do. The point of African Americans participating fully in the political process was not just symbolic. Yes, it is true. It is the ultimate reflection of full citizenship in this country, the ability to cast a ballot, to participate equally in the political process, and so it was critical for that reason. But it was also expected to allow African Americans to have a role and to take the power to change the material condition of our lives. That was the whole point of participation in the political process. And in that realm, I would say it's a little bit less successful. And, you know, if you look back to Dr. King's, one of his most famous speeches, Give Us the Ballot, which a speech he gave in May 1957 at the Lincoln Memorial, and the speech was really designed to address the failure to implement Brown versus Board of Education. But in that speech, he goes through saying, give us the ballot, give us the ballot, give us the ballot. And he says, give us the ballot, and we will, you know, elect representatives who can be transformative. He says, give us the ballot, and we'll elect judges in the South, referring to the previous panel, who will do justice and have mercy. And we'll elect people to the governor's seat, who will have a touch of the divine. I mean, he had this kind of elevated sense of what this could mean transformationally. And that aspect, I think, is the part that is still unfulfilled. And I'm sure in this panel we'll talk more about the ways in which it's been unfulfilled, but I think that's the piece that we're sitting with. And I think there are lots of reasons why it's unfulfilled. It's one of the reasons why this panel, although it comes second in the day, in many ways touches on all the other panels throughout this two-day symposium, because voting rights is connected to education and connected to criminal justice and connected to education and all the other issues that we're talking about over the next 2 days, is this sense of how do you unleash transformative political power for marginalized groups. King certainly thought that that potential was there, but I think he also recognized the scale of the challenge, and we haven't fully scaled that wall yet.
Can I just jump in and say here, you know, Sherilyn is 100% right that the Voting Rights Act of 1965 is the crown jewel of civil rights laws, and it's the centerpiece of what came to be known as the Second Reconstruction. One of the things it's worth remembering is there was a first Reconstruction, and that first Reconstruction failed. And so if we were using a figure, I'll just use one figure, which is 80%, which is during Reconstruction, 80% of black men voted in the United States. And then that number went down below 1% by 1900. So it's important to recognize that Reconstruction is an ongoing process, and the first Reconstruction failed in part because of the disenfranchisement of African Americans in the South. And that's one of the reasons the second Reconstruction was necessary. The second thing that Sherilyn pointed to that I want to highlight, Dr. King's Give Us the Ballot speech is a wonderful example of this, is the idea that voting is really about three very separate things. The first is that symbol of full citizenship. The right to participate, the right to cast a ballot and have it counted. And when Sherilyn and I were doing voting rights cases full time, everybody assumed we had solved that first generation problem, and we were on to what came to be known as the second generation problem, which was voting's not just about the symbol of your ability to cast a ballot and have it counted, it's also about who wins and loses elections. And so we spent a huge amount of time on redistricting cases and judicial election cases to set up systems where African Americans and Latinos could elect the candidates of their choice to these offices. And we thought we had that kind of on the run. And so we were starting to think about that third generation of cases, the cases about governance and about making changes in legislatures. And that was what Dr. King's Give Us the Ballot speech was really about, was you give us the ballot and we go straight to the third generation of cases. And so he said, you know, we'll be able to get rid of things like stagnant and hypocritical federal Congress. Sound familiar? And then he talked about the blatant hypocrisy of right-wing reactionary Northerners. Sound familiar? And finally, he talked about how giving the vote to everyone would get rid of the high blood pressure of words and the anemia of deeds, dealing with the issues of critical importance to people of color in this country. And we haven't gotten to that third generation yet. Indeed, what we're now seeing is we're back litigating the first generation again. So the very issue that was at issue in 1965, which was the ability of people to register to vote, to cast a ballot, and to have that ballot counted, is back on the front lines again. And that's absolutely critical for people to remember, that we can't really talk effectively about the third generation of problems until we solve that first generation problem so that everybody can vote.
Sure. Rick?
First, let me say it's an honor to be here, and I don't feel like I'm worthy of being on this panel, but I'm very, very happy to be included. First, I'll give a grade, since you're always supposed to answer the judge's question.
Thank you.
I'll say gentleman's C, you know, a C to be nice, because I do think that, especially if we're averaging it over time, I think the Voting Rights Act, when it was passed, that was a tremendous progress, but over time, we've lost a lot of the promise of where it was going. And if you read Dr. King on what his vision was of what the vote was going to lead to, he talked about coalition politics between African Americans and other Americans, and he talked about how that was going to better the lives of everyone. He talked about the Medicare, education, social justice, criminal justice, all of these things were going to be improved. And so if we think about why that didn't happen, going to the last part of your question, Steve, I think there are three main reasons why Dr. King's vision has only been partially fulfilled. The formal right to vote, of course, is there, but where's the material change in the position of African Americans and others in the country who were put at a disadvantage before the right was there? And the first thing I'd say is that parties have long been able to harness private racism towards political ends. First, it was the Democratic Party with the all-white primary, and that took Supreme Court action to get rid of. Today, it's the Republican Party trying to turn at least in the South, trying to turn the Democratic Party into the Black Party and to send a symbol that if you're a white voter and you're looking for the place to go as your party, you should not go to the Democratic Party. And so there's been this kind of message that's being sent as to what it means to be a Democrat or Republican that has racialized the politics in our country. The second thing is, and Pam alluded to this, is the failure of the Supreme Court to read the Voting Rights Act with the spirit of what it was meant to do in mind. And so the litigation attempts, which some of the panel were involved in, to try to get the Voting Rights Act applied to areas of governance, to apply to how legislatures do their job, has failed. And the Supreme Court has consistently rejected broad readings of the Voting Rights Act, going so far as in the Shelby County case to strike down a key part of that provision, and is now poised to make Section 2 of the Voting Rights Act, which is the main tool that's left of the Voting Rights Act, a much less effective tool than it has been in the past. And the third area, and we may get into this, is, and this is partly the Supreme Court's failure, is the role of felon disenfranchisement, which in terms of the numbers of African American voters is just staggering. It was not the case at the time that Dr. King was speaking about voting rights. But if you just take into account the numbers of African Americans and others who have been disenfranchised because of felony convictions and the Supreme Court's failure to allow constitutional litigation to try to challenge that, I think that's a big part of the picture for why the voting rights vision of Dr. King has not been fulfilled.
Debo, did you want to comment on that?
Sure.
question?
So I will, as the only non-professor on the panel, brazenly ignore the request to assign a grade.
I'm used to it.
But I will pick up on some of the comments that my other panelists put on the table. I think that as we reflect on the years in voting since the passage of Dr. King and his great example and the movement that led to the Voting Rights Act, we have to think about a couple of things, and some of them have been put on the table. In particular, I like to think about how it is that we understand what progress means in the context of civil rights and what it doesn't mean. And that's an important theme that has run through the, you measure progress, when is enough enough, and do you dishonor progress by acknowledging that the aspiration is to do more and to push beyond what the current situation is. I think there's a little bit of a tendency to want to declare victory with respect to certain civil rights issues, and to come to understand or to treat the goal as if we're trying to move from a state of total privation and discrimination and racial caste to something that is ameliorative but not full participation and citizenship, and to settle in that space. And the aspiration of the Constitution, I think, of many Americans is to keep doing more, to perfect the Union. And the Voting Rights Act had that ambition. It was there to continue to push forward and not to use our progress to date as a limitation on what we can achieve tomorrow. And if you think about that mindset, that tension between wanting to declare victory and the ambition and aspiration to do more, that is essentially the debate that Congress had every time the Voting Rights Act provisions came up for renewal. They would measure office holding, voter registration, the amount of cases that were decided, Were some parts of the country worse than others? And there was this intense battle fighting about whether or not delineating all of the continuing problems was somehow dishonoring the passage of time and the progress. And I think that we are smart enough to hold both concepts in our mind simultaneously, that you can acknowledge and embrace progress. After all, that was the objective. It was Dr. King's objective. It's the objective of every civil rights law. But you can also own and wrap your mind around the fact that racial discrimination in our country has tended to be more persistent and to insinuate itself into more areas of the country, and in some cases to metastasize in ways that we didn't expect. And in the face of that reality, I think the need to do more is important, and that was what was coming to a head in the Shelby County case. A need, and that was the case that struck down core provisions of the Voting Rights Act. And it was the court's hunger and thirst to declare that we were in a different place, in a different era, and we had closed the book on those old days. And what have we seen in the wake of the Shelby County case? What we have seen is that we were treating symptoms and we were treating some of the causes, but we certainly had not stemmed the disease. And it has metastasized, and so we see lots of the voting measures and tactics that had been used in certain places jumping to other places. And so Justice Souter once called it pouring old poison into new bottles. And I think that's part of the challenge in the voting rights context today.
Well, thank you. And I just want to follow up on a couple of comments that have been made just for clarification purposes to make sure the audience is with us. So I believe it's already been made clear, but the Shelby County v. Holder case that you referred to, Debo, is the one where the Supreme Court effectively ended the preclearance provisions of the Voting Rights Act. So you no longer had to get preclearance of voting changes in advance to make sure they weren't discriminatory. Is that correct?
Yeah, and it had applied to some parts of the country that had the biggest demonstrated histories of discrimination in voting. And so some parts of the country had to essentially have new voting measures pre-approved before they could take effect, on the theory that the pattern of discrimination had been so consistent that it was putting a burden on voters, and they were having to try and dislodge discriminatory practices one by one, and it takes a lot of time. And so it shifted the burden of time and inertia, as the court said, from the people that were having the discrimination perpetrated on them to the would-be discriminators, and made them come forward and show that the new measure was not discriminatory. And that was the very important piece to which Sherilyn and I have referred that the Supreme Court took away.
Right, thank you.
And then, because it's actually worth spending a minute on the Shelby case, because I think it actually illuminates a lot of what's been discussed, and Debo has described it perfectly, and since he argued the case, he knows that this is in fact true.
For this audience.
In many ways, the Shelby case and the Supreme Court's treatment of the Shelby case reflects what I think Pam was referring to earlier, which is a kind of proclivity to regard the issue of confronting racism in public life in this country as a finite issue that has to be dealt with at particular moments, and that you tolerate the fact that you have to deal with it, but then it's going to be over. And then we're going to go back to, I don't know what we'd be going back to since it's always been with us, but nevertheless, there is a sense that there's a kind of temporary measure. And I think that pervades almost all of the kind of civil rights jurisprudence that I think has been so reactionary certainly in the last 20 years of the Supreme Court. And I think Dr. King recognized this. I mean, he talked about the fact that the success that had been achieved after the Voting Rights Act of 1965, he described it as, so we had the Civil Rights Act of 1964, we had the Voting Rights Act of 1965, and we didn't have the Fair Housing Act passed, frankly, in shame until a week after Dr. King's assassination. And what he said with the two major civil rights statutes that had been passed was that we had just achieved a measure of decency, right? A requirement that African Americans be treated decently in our society. And he said very explicitly that the next stage was going to be so much harder. He said that the decency piece didn't cost anything. He said it didn't really cost any money to ensure that African Americans were registered to vote and could participate in the political process. What would begin to cost money were the measures around housing and inequality and poverty and so forth. So when you look back at the civil rights movement, it seems like such a, was such a harrowing period. But he recognized that in many ways that was going to be the easy part. That convincing people that this was a much more long-term and in fact permanent struggle was going to be the difficulty. And so what you saw from the Supreme Court in the Shelby decision and what you heard from Justice Scalia, who in the oral argument described the Voting Rights Act as a racial entitlement. Now, Dabo was standing in the well of the court maintaining his composure. You know, I was sitting with our clients, our Shelby County clients, and I could feel the indrawn gasp. Right? We had of course instructed them that, you know, we need to be quiet during this hearing. We can't respond. But the indrawn breath when Justice Scalia described the Voting Rights Act as a racial entitlement. And when you heard the kind of questions that were coming from Justice Roberts and Justice Kennedy, and when you then read the opinion, the decision that it's over, the decision that we've reached a certain level and now we need to stop this unnatural intervention. As though the natural state of American affairs is that we would always need intervention to deal with issues of racism. And so I think this is something important for us to remember when Pam says we're kind of back to that first generation. I don't think we can do the generation seriatim anymore. We have to recognize we're always going to be doing all three. We're going to be doing the first generation, we're going to be doing the second generation, and we're going to be doing the third generation, and we've got to figure out how to do them together.
And that actually is a great segue to the other clarifying question I wanted to ask. I wanted to make sure that it's clear to the audience what the three generations are. Pam, you had mentioned that we never got to the third generation that Dr. King had envisioned. In fact, we're still now we're fighting the first generation again. I wondered if maybe you could explain what you mean by that. What are the first generation problems that we thought had been solved and now are cropping up again? In what way?
Yeah, so the first generation is the right to register to vote, to cast a ballot, and to have that ballot counted. And we're seeing problems with all of these, and I'll just give a couple of examples from some cases that I was involved in litigating at the Department of Justice. So the right to register. Some states are now trying to require people to show proof of citizenship in order to register. And for most of you in the audience, that might not be that hard to do because you've traveled overseas at some point, so you have a passport. Or you drive a car, so you have a driver's license from a state that's compliant with what's called Real ID. But for huge numbers of Americans, particularly Americans of color, they don't have the documents that would show that they're a citizen. They're too poor to own a car, so they don't have a driver's license. Or they're too old to still drive, so they've let their license lapse. Or for many elderly African Americans and Latinos in the South, they were born at home and never got a birth certificate. Or the birth certificate was filled out by somebody who didn't have, who had like a 4th grade education, so their name is misspelled on the birth certificate or the like. And so, for example, in Texas, there are 600,000 people who are now registered to vote who can't vote because they lack compliant government-issued ID. So the first thing is, it's hard to register to vote, and if you move a lot, and poor people tend to move more often than wealthier people, you have to re-register in some states everywhere you go because the state doesn't really automatically re-register you, although they're supposed to do that. Then there's casting a ballot, showing up on election day. Well, in states that now have voter ID laws, lots of people don't have that ID, and they go to the polls and they're told they can't vote. Or they work 3 jobs because they're trying to keep food on the table and the state doesn't have early voting or doesn't have weekend voting or has cut back on Sunday voting and the souls to the polls. Or they show up at the right place to vote but in the wrong line, and rather than telling them go to the other line, they're handed something called a provisional ballot. And although the federal government requires the state to give you a provisional ballot, they have no rules on whether it should be counted or not. And so lots of people show up and cast a ballot that they think is going to be counted and doesn't get counted. And those problems are all getting worse in part because of the disappearance of preclearance, which is why, for example, Texas was able to put its voter ID law into effect. Alabama is able to put its law into effect. North Carolina is able to try and get rid of early voting or to try and get rid of same-day registration or the like. So those problems are recent problems, and that's the first generation.
Right.
The second generation is about the ability to elect candidates of your choice. It's about the rules that translate votes into wins. And the biggest one in the United States involves the way we draw districts. because it is probably as true today to say that every 10 years your representatives go into a room and pick you, as it is to say every 2 years you go into a room and pick your representatives. Because the sophistication of the technology for gerrymandering has gotten so much better since the 1960s that now there are huge numbers of elections in the United States in which we know the results 2, 4, 6, 10 years in advance, because literally nothing that's going to happen in the interim is going to change the outcome of those elections. So that's the second generation, which is mostly about things like districting. And there, the Voting Rights Act was critical, and pre-clearance was critical in stopping the covered jurisdictions from changing the way they did elections to make it harder for communities of color to elect candidates of their choice. It's now April of 2018, and we are still litigating whether the plans that were drawn in North Carolina and in Texas after the 2010 census fairly represent the African American and Latino populations in Texas and the African American population in North Carolina. So we're going to get to 2020 with maybe one election conducted under a plan that fairly reflects minority voting strength. That's because in the old days, the Voting Rights Act stopped those plans from going into effect, and courts could draw fair plans in the interim. Or more to the point, it told the states, you're not going to get this kind of plan pre-cleared. And the Supreme Court was vigorously enforcing Section 2, which they're not really doing anymore. So that was the second generation. The third generation is this idea that you don't just care about the dignity of yourself getting to cast a ballot and have it counted, although that's super important. And you don't just care about whether you're able to vote for a winning candidate in your district, but you care about the overall composition of the legislature, because that's what determines who gets things done. You care about the coalitions that your representatives can build inside the legislature. And that's the third generation, and that's the generation that the Supreme Court said the Voting Rights Act has nothing to say about.
Now, thank you very much. Each one of you has mentioned the Voting Rights Act and its centrality, right? And I think obviously that's the case. Dr. King and his work was obviously crucial in the passage of the Voting Rights Act in 1965. If you were to be able to write a new Voting Rights Act today, or to make amendments to it, what changes do you think are essential? I'll take anybody.
So I guess there are a number of the problems we've discussed need to be considered, right? But the question is, in what time frame will these things be considered? So let's just be optimistic here and talk about what the issues are and what legislation might consider, because it's important to the voting process and to full inclusion. The key thing that the Supreme Court was quibbling about in the Shelby County case that we keep referring to is the passage of time and when there is a break in history, right? So essentially what they were saying is, because the piece of the Voting Rights Act of which we spoke, the pre-clearance provision, tended to focus on many parts of the Deep South, not all, but many parts that had